Today, Shri Rajiv Jiwan ji will be addressing on Directive Principle of State Policy, the Constitution of India. Now, without taking much more time, I will request Shri Rajiv Jiwan ji to address.
श्रीमती सुचित्रा ठाकुर, अधिवक्ता, हिमाचल प्रदेश हाई कोर्ट और मेंबर नेशनल एग्जीक्यूटिव अधिवक्ता परिषद, श्री अमित चंदेल, एडवोकेट, हिमाचल प्रदेश हाई कोर्ट, जनरल सेक्रेटरी अखिल भारतीय अधिवक्ता परिषद हिमाचल प्रदेश, अध्यक्ष श्री लोकेंद्र ठाकुर जी, हिमाचल प्रदेश हाई कोर्ट यूनिट अधिवक्ता परिषद, जनरल सेक्रेटरी श्री अविनाश जरियाल, अधिवक्ता हिमाचल प्रदेश हाई कोर्ट, जनरल सेक्रेटरी अखिल भारतीय अधिवक्ता परिषद हिमाचल प्रदेश, और यहाँ उपस्थित सब गणमान्य लोग, मैं आप सबका धन्यवादी हूँ जो इस मौके पर मुझे राज्य के नीति निर्देशक सिद्धांत विषय पर बोलने का मौका मिला। Let me tell you that this topic of Directive Principles of State Policy is very dear to me. I vividly remember to have addressed an audience on the said topic on the Constitution Day in a function of the High Court of Himachal Pradesh. I'll be fairly informal with you people, and I treat this occasion as an occasion where I would be laying bare whatever at my disposal and will be expecting any questions from anyone in the interactive mode. If I begin with, let me initiate that our Constitution is a harbinger for multitudes of the people constituting the woof and woof of our country, having multiple cultures, multiple lifestyles, multiple tastes, and multiple conventions, traditions. Taking care of that, Directive Principles of the State Policy, which find mention in our Constitution at Part 4, so that the common policy for the weal and welfare of the people, state would formulate. The very name Directive Principles of State Policy itself denotes that state will be formulating a policy drawing succor from the Directive Principles of the State Policy. The topic has very wide dimensions and has its shadows which cannot be measured in a short time. But I'll try to summarize it to my little baby wisdom. Whatever I could perceive, I would share with you. History books let us know that directive principles we have incorporated in our Constitution from Ireland, and they find part of the Constitution in Part 4 and getting embedded under Articles 37 to 51 of the Constitution. they essentially carry in their womb a sucker to the society to thrive, to move with all facility, and then to ensure the country, the society gallops in all mirth. Technically, we owe these directive principles to some other country, but I must let you know that those were having their roots in our ancient past, in our country which had a very rich and lavish culture to recline upon. Our Vedas, Smritis, Upanishads, whatever disseminated from those holy books, we find that directive principles, they smell the tint, the color, the texture of our culture. The holy aims and goals which are carried by directive principles of the state policy, they in fact constituted the complete matrix of our culture, our society. What Western world, the rest of the world is trying to create by causing creation of so many conventions and treaties, those were long back adhered to in our culture. Sarv Dharm Sambhav. It's a proud example of secularism. This what we had already invested in our past. Vasudev Kutumbakam. It plays a very peculiar keynote in the orchestra of Oriental teachings. Saving our trees, worshipping our elements of nature, worshipping sun, moon, trees, water, respecting anything which existed in life on this planet. That is what we were taught. Directive principles of state policy essentially deal with the weal and welfare of the society. They may not be justiciable, but as the world grew up, society developed, the thought also flourished. The things we only thought could not be implemented as a matter of right from the courts, those have started happening through the courts. We file public interest litigations for the protection of the environment, for saving the interest of the downtrodden, for the tiller, for the laborer, for the hygienic food. Courts are emboldened of late, taking strength and ride on the back of the directive principles of the state policy to issue directions to the legislature, to even enact statutes to protect the interest of the society. That is the supreme thing. To give a little summary before I further advert on the issue, I'll be reading a little part of the Constitution in my own mode, that which article provided and where the directive principles of the state policy are embedded. Article 39B provides for securing the distribution and control of material resources of community in such manner as to best subserve the common good. In this direction, certain agrarian laws were enacted to prevent concentration of land holding, even in the hands of the actual cultivators, inviting ceiling of maximum area qua an individual. Article 40 of the Directive Principles goaded the state to organize village panchayats, conferring them with the powers of self-governance. Article 43 of the Directive Principles stirred the state to establish several boards to advance the cause of cottage industries. The most sensitive issue with respect to compulsory primary education was taken care of by the state, inspired by Article 45 of the Directive Principles. Raising the standard of living of the rural population by launching community development project in 1952 was thanks to Article 47. There are very many centrally aided schemes which are floated, taking a ride on the boat of directive principles of the state policy, like the Integrated Child Development Scheme. Although it was UNICEF aided scheme, but the state of government of India was stirred by the directive principles of the state policy to adopt such scheme and float it in the country. And every nook and corner of the country is now covered by that scheme, taking care of the nutrition of the children, of the infants, the lactating mothers. So those were not the part of the fundamental rights, but directive principles stood asserted in such a manner that legislature conceived that the weal and welfare of the people of the country is the sole touchstone of enforcing any statute, law, or enact any legislation, taking strength from directive principles of the state policy. Directive principles of state policy were given new dimension from time to time, but how it evolved insofar as judicial arena is concerned, I'll be giving a little narration of that to have a complete and comprehensible grab on the issue. In the case of State of Madras versus Champakam Dorai Ranjan, it was held that the directive principles of state policy have to conform to and run as subsidiary to the chapter of fundamental rights. That was the initial and nascent take of judiciary on directive principles of state policy. The said view continued to hold good and stood reiterated through various judgments. And in the case of Deep Chand versus State of UP, Honorable Apex Court went on to hold that disobedience of directive principles cannot affect the legislative power of the state. So was the view taken in Kerala Bill case, 1957. However, Golaknath versus State of Punjab case triggered a tectonic shift from earlier stand and grab of the Supreme Court, and Supreme Court departed from the rigid rule of subordinating directive principles to fundamental rights and ushered an era of harmonious construction between directive principles of state policy and fundamental rights. Finally, the riddle was pounded and bobbin was unrounded. It was the case, a marked case of Keshwananda Bharati versus State of Kerala. In most uncertain terms, the apex court held it's a very beautiful thing to happen and a laudable thing to happen, a step progressive in the footholds of this country, that the Honorable Apex Court held that our constitution makers did not contemplate any disharmony between fundamental rights and the directive principles of the state policy. It further held that it can be well said that directive principles prescribe the goal to be attained and fundamental rights provided the means to achieve such goals. Later on, in the case of V. Markande versus State of Andhra Pradesh, it was held that fundamental rights, it went on qualifying and directive principles acquired more and more significance, where it was discovered that whatever we enact and whichever enactment creates a right, that is created under the light poles of directive principles of the state policy. Court expressed one of the best of the expressions, fundamental rights and the directive principles constitute consensus of the Constitution. List of cases is unending, but still I would advert to the neighbouring state Punjab and Haryana High Court's judgment, which was popularly superscribed by the dailies under the caption "Right to procreate to jail inmates." Although Punjab and Haryana High Court dealt with the issue under the fundamental right as enshrined under Article 21 of the Constitution of India, but a close look at the judgment shows that the right was appropriately grabbed and located under the searchlight of human rights and fundamental freedoms set out in the Universal Declaration, which and human rights, but I must say they are playing a veritable sister to the directive principles of the state policy. All said and done, despite directive principles holding unshakable, unwashable, indelible place and niche on the chest of the Constitution, but despite all that, our country is still in pursuit of providing adequate food and generate employment. Thus, a substantial chunk of nation is still deprived of means of basic subsistence, hindering the optimum growth and development. Issue of bread and butter still looms large. Large number of people, they profess a profession only for the sake of seeking the bread and butter. They are unable to chase a profession which is close to their passion. And if somebody is forced to pursue a profession which is not close to their passion, anybody could imagine there will not be an optimum contribution for the growth of the country. Situation is such that a person who could prove to be an ace surgeon for want of resources could not study and is forced to do the job of a cobbler, sewing the shoes with the most dexterous fingers, which could have cured large number of people thronging the hospitals. Article 47 provides the duty of the state to raise the level of nutrition and standard of living and improve public health. Although well-meaning legislature has enacted Food Adulteration Act, but the same deserves to be more effective and potent. Similarly, to deal with the drug menace, effective and substantive task forces are required to prevent the illegal production of drugs and abuse thereof. Education standards cannot be allowed to brook any variation in imparting the same equally, barely synchronized with the pace of automated terror machine. I may point out, since lawyers, advocates have congregated here, that your role is very important in so far as carrying out the implementation of directive principles of state policy. You are the biggest instruments in the true implementation of various facets of the Constitution. And it is true for the directive principles too, even pushing the legislature for enacting various laws for public welfare schemes. And it so happens that sometimes you ensure that the judicial monitoring of such schemes is there, and thereby you contribute enormously to the evolution of directive principles of the state policy. Public interest litigations filed by the advocates flood the courts. They are the biggest motivations of the courts to pass orders, directions in the sphere of achieving the laudable goals of directive principles, such as environmental protection, prisoners' weal and welfare, animal protection. The list is long, but the bedrock is that it is the welfare of the society. The pristine drive of the government to protect the rights of the tribals and forest dwellers, as well as forest conservation enactments, is also inspired by the directive principle of state policy. Finally, before I get washed away with the enormous flow of the evolution of the directive principles of state policy, I must confess I am in complete disagreement. I am reiterating, I am in complete disagreement with the people who think that the seminars and celebrations are to be ticketed as pariahs or untouchables. I may share that the fate of very many battles and games are sealed while discussing the nuances of the same, stirring your straw in the coffee cup. Over a cup of coffee, today perhaps I have tried to exhibit whatever was at my disposal in deference to the directive principles of the state policy. And I hope today's address will provide lots of fodder for deliberations on our solemn constitution, and this take of mine with my baby wisdom on directive principles of state policy will be received with mirth, joy and happiness, which I may exude in my later addresses too. Thank you.
Now I will request Sri Avinash Jaryal ji to give vote of thanks.
मैं अधिवक्ता परिषद हाईकोर्ट यूनियन की तरफ से श्री राजीव जीवन सीनियर एडवोकेट का बहुत बहुत धन्यवाद करता हूं कि आज वो हमारे स्टडी सर्कल में आकर के उन्होंने फंडामेंटल ड्यूटीज़ के ऊपर हमें जो ज्ञान बांटा है या हमें अवगत कराया है, उसके लिए बहुत बहुत धन्यवाद। और मैं अपने सीनियर एडवोकेट श्री अंकुरदास सूद, श्री लोकेंद्र ठाकुर जी का भी धन्यवाद करता हूँ कि आज वो हमारे बीच यहाँ